Car accident claims and arbitration. Arbitration is used as an alternative way to resolve disputes. During arbitration, an arbitrator will hear all of the evidence presented from both sides and decide upon the result. During car accident claims, an arbitrator will decide upon which elements of the case are the most important. For example, they may ask, "Do you wish to recover a settlement from the at-fault driver? How much do you wish to recover?" One of the great things about arbitration is that it can save everyone a lot of time and money. This is compared with taking the case to court. There is another similarity between arbitration and court cases, and this involves the final decision being made. Just as a judge in a court would make the final decision about a case, an arbitrator would also make the final decision. How mediation and arbitration differ. Arbitration and car accident mediation are different in the way the claim is resolved. For example, a mediator will try to get all of the parties to agree to a resolution. However, when it comes to arbitration, an arbitrator has the power to make the final decision. Agreeing to arbitration. Arbitration will only ever take place if all sides agree to go ahead with it. You should be aware that an insurance company cannot force you to go into arbitration, and vice versa. However, you can all agree on who the arbitrator will be. This will typically be a lawyer who is experienced in car accident claims. However, there may be arbitration groups in your state who can recommend someone to you. The insurance company may also suggest someone, but you may want to take a close look at who they are suggesting so you can determine whether you think they are suitable. The final decision. The arbitrator's final decision is just that, it's final and you cannot appeal against it. You should be aware that the arbitration process saves both time and money when compared to taking a car accident case to court. You should also be aware that you can use medical records and bills as evidence during the arbitration process. You can do this without bringing in a witness such as a medical expert. However, you will need to make sure you can prove any loss of income due to your injuries, and of course, your medical bills. You can use the high-low agreement to your advantage. What this means is that the arbitrator may decide you will not recover more than $20,000, the high amount, for example, or less than $5,000, the low amount. Occasionally an insurance company may ask you to consider using a high-low agreement. However, you should be aware that if you are offered a $25,000 settlement, you will only receive $20,000. If you are offered a $3,000 settlement, you will receive $5,000, as $5,000 is the low amount. When it comes to receiving a settlement, you should be aware that there's likely to be an administrative fee to pay. This fee is usually the arbitrator's charges, and the amount in question will be based upon how much time the arbitrator has spent on the case. What happens during the arbitration process? Typically, an arbitration is structured quite like a trial. However, the procedures tend to be a lot less formal. Firstly, an opening statement is made during which you give your side of the story. You will then give your evidence and you will testify under oath, explaining your case. While explaining your case, you can talk about how the accident occurred, why you think the other driver is to blame, and what damages occurred. When it comes to giving evidence, you should have all of your relevant medical bills and records with you, along with proof of your loss of income. If relevant, you can call upon any witnesses to your accident as well as those who can tell the arbitrator how the injuries you sustained have affected you. It will then be your opposition's turn to present their evidence, and at this stage, you can cross-examine any witnesses they call. Once the evidence has been presented, you can then make a closing argument. In the closing argument, you can explain what you have proven to the arbitrator, and you can also describe how much you would like your award, settlement, to be. It will then be the opposition's time to make their closing argument. The arbitrator can make a decision about your case there and then, but they may also decide not to. If, for example, medical bills have been used as evidence, the arbitrator may need time to review them, in addition to any other evidence that has been presented. You should expect to receive the final decision in writing within 2 to 3 days. Arbitration tips. 1. Prepare well in advance so you have as much evidence as possible. Make a note of what you would like to say and place all of your pieces of evidence in order. Talk with any witnesses and work out what questions you'd like to ask. Make a note of any questions that you have for the insurance company and any witnesses they bring along. Lastly, plan both your opening statement and your closing statement carefully and make sure they are as persuasive as possible. 2. Use any photographs you have of the scene of the accident. You may also want to bring any support braces that you've used with you. Use diagrams and drawings to help you illustrate your points. 3. Anticipate what you think the insurance company will say, and more specifically, what they will argue. It's likely that you will already know what their arguments may be, as you are likely to have been in discussion with them before. 4. Try not to feel intimidated by the insurance company's lawyer, if they have one present at the arbitration. You personally experienced the car accident, and therefore you have an advantage over them, and you also know the real facts. 5. Don't be tempted to exaggerate what happened, just be sincere. Argue the facts and stay in control.